time. I want to welcome Leah Wing, who is the director of the National Center for Technology and Dispute Resolution at the University of Massachusetts Amherst, who is a key player in organizing the annual Cyberweek event, and we're very glad to see you today. I don't know if you want to say a word of welcome or just stay in the background, but if you do, this is your chance.
Thank you. I am thrilled by this topic and by the expertise on the panel. Frank is a mover and shaker in ODR for 2 decades now, and he's pulled together an amazing panel with experts from right across the board. Thank you for the work that you're doing on this important topic, and thank you for being here to contribute to Cyberweek. For all the guests online, welcome if this is your first session, and there's more to come. I'll leave that to Frank now. Thank you very much.
Thanks. So my name is Frank Fowlie. I'm a fellow at the National Center for Technology and Dispute Resolution, and hopefully you'll hear very little from me today. I am pleased to introduce the topic, and I am going to allow our panelists to introduce themselves. What we're going to be talking about today is the largest administrative tribunal in Canada, which is the Immigration and Refugee Board of Canada. It's the organization that is a standalone quasi-judicial organization that makes determinations whether or not applicants for refugee or immigration status meet the requirements under Canadian law and international conventions. In 2020, the tribunal, to my recollection, had something like 60,000 refugees in line for determinations. And all of a sudden, the courtrooms and the hearing rooms were closed. And so, in my mind, as an ODR practitioner, IRB made an amazing pivot to go from a bricks and mortar environment to an online environment. So I'm pleased to welcome 2 folks from the Immigration and Refugee Board, our Refugee Protection Division and Quality Control Center, who are going to talk to you about that pivot, and keeping up services for people who want to be Canadians and dealing with what would have been an ever-growing backlog. And they'll talk a little bit about the hunt for technology and implementation. And then we're going to be, in the second half hour, we're going to have a colleague from the Cyber Justice Laboratory at the University of Montreal. And his role was to come to the IRB as a contractor and conduct an evaluation to see how well this pivot worked and to provide recommendations to the IRB on improvements that can be made. And Nicolas has been with Cyber Justice for at least 15 years and is one of the movers and shakers on probably one of the leading academic institutions that has a program devoted entirely to putting justice into the cyber environment. So without further ado, I'm going to take the screen share off, and I'm going to ask Negar and Josh to talk about the experience of pivoting on IRB and the experience of moving a tribunal into an online environment. We'll take whatever time we have left at the end. Hopefully we'll have 5 or 10 minutes, and we'll open that for questions. If there are burning questions, please feel free to use the chat, and we'll try to interpose them if that's possible. So Negar, Joshua, over to you.
Thank you very much, Frank. We divided up our time where I'm going to go through 15 minutes to set the stage, talk a little bit about the organization and the pivot that we have. we'll then hand things over to Nicolas, and we wanted to then leave a substantial amount of time for questions and answers to really be able to respond to what you are most interested in. So I've got my timer going, and we'll do this introductory part, and then Negar and I will answer questions along with Nicolas at the end. In terms of who we are, and individually, I'm Joshua Prowse. I worked as a lawyer in Canada, and for the last number of years, I've been an adjudicator with the Immigration and Refugee Board of Canada. I specifically work with the Refugee Appeal Division that handles appeals of decisions related to refugee status in the country. And I've also worked as an executive with the Canadian government on implementation of digital initiatives. In terms of the Immigration and Refugee Board, it is this gives you a sense of where we have offices, the number of staff that we have, and essentially, if somebody applies for asylum or refugee status in Canada, they will have their file adjudicated by this independent tribunal. For those in the audience who are particularly from America, the process here could be roughly likened to that of the immigration judges in the US. And to put it colloquially, our mandate is to find the refugees and offer them protection, and to do so in a way that's consistent with a spirit of welcome, something that's said in some of the founding reports that came from the time that this tribunal was being established in the 1980s. The situation was well described, I think, by Frank, who talked about the nature of refugee status determinations involving relatively large volumes of claims. And when it came time to for COVID, we had a large number of people, and we have for a long time dealt with claims using video conference. But that was always between government offices, never with individuals using personal devices in order to attend a hearing. And so this shows you who is typically involved in these types of hearings that are occurring. And you can see particularly the role of the interpreter and the role of a representative for the government that can contest claims is listed there, as well as counsel for the individual who is applying for refugee protection. So these were the sort of actors that we thought of as we were at the beginning of the pandemic, looking at how we would implement this pivot to be able to continue operations during the pandemic. And at that point, one of the key things that we did was turn to the board's stakeholders. And so just to sort of take a step back, I think one of my goals of this presentation is just to highlight a few of the values or lessons learned that went into key decisions along the way that probably apply more generally to other pivots and other technology moves that any institution may make. And one of the key aspects and really valuable things that the Immigration and Refugee Board has is its relationships with a vibrant community of stakeholders, including non-governmental organizations, the United Nations Refugee Agency, and others across the country and internationally. And so when the pandemic happened, we started convening virtual meetings with these organizations. They provided detailed written submissions about their views on virtual hearings and the important considerations in this pivot. And we worked with them, trying to be very, very open as the process went along. We initially implemented this process as a pilot project and then solicited feedback from people who opted into it, and then conducted preliminary evaluations on that pilot project, and then more significant empirical evaluations over time, both internal and external. Some of the key aspects of the model that we implemented, one was security. We worked with Microsoft to deploy a secure version of Microsoft Teams. We looked at things like data residency, and this is a sine qua non for implementing this type of process in the refugee determination context, where privacy is very important. But then we also looked at how to do this in a way that that was user-friendly. We produced guides, we brought in plain language experts for our forums. We tried to have a significant amount of handholding built into the system. So having registry staff meet before every hearing with the participants to check on their audio and video. And also we partner with non-governmental organizations in order to deliver what we call RIDI tours. So, and we mention these in the materials that we send out where people are getting ready for their hearing. And this allows an individual to meet virtually using the same Microsoft Teams software that we are using for our hearings with a non-governmental organization some weeks or months in advance of their hearing, both to get ready and to understand more about what to expect with the hearing that's happening. And so we worked closely with these non-governmental organizations across the country in order to ensure that they could pivot all of their operations into this online environment. We tried to also come up with a set of clearly communicated requirements. For example, one of the things that we thought a lot about was security in the context of like what happens, for example, if an individual's private device might be hacked or somebody could be intercepting communications. And so that's something that we worked a lot on. And at the end of that, we shifted to a process where we are conducting, still today, the vast majority of our hearings now using this process. We ensured with this transition that we were measuring how things were going, both in order to have dialogue and be able to identify pain points. So we implemented things like an automated post-hearing email survey that gets sent out, where we have people then look at those survey results, identify particular opportunities for improvement based on those survey results. We also implemented a whole system at our offices for those without technology to ensure that there was that access to justice and to be able to offer a lot of different permutations of access to hearings. So a claimant, for example, could come to our office while their counsel was connecting remotely. And since we implemented this, we conducted tens of thousands of hearings. I think it's over 100,000 claims that have been dealt with through one of these proceedings at this point. In terms of some of the particulars of how we dealt with some of these things, I've highlighted a few of these. At first, when we were looking at what sort of technology do we offer to assist those who are without appropriate technology to connect to a virtual hearing, we rigged up these sorts of carts in our offices We then eventually moved to a model that used more sophisticated screens that were already on our walls and had different video conferencing software interact in a way that should be quite straightforward for the end user. This is an example of the sorts of tips sheet that we email out, like a little thumbnail that links to this, where we tried to keep it simple with some of the communications, be visual, and worked on things like translating this into the top 10 languages of people who are connecting to our hearings. And as part of our transition, we also worked on really expanding the use of what we call My Case, our online portal that allows people to log in to access information. And this shows some of the challenges that we have in terms of maintaining privacy. For example, we don't send out email communications to people. And so even basic things like the best way to exchange those sorts of documents were something that required us to look at this type of portal and expand that. And it fits in also to a broader view of how we assess and measure quality in our decision-making processes. And that sort of measurement for this particular initiative related to virtual hearings is something that we really brought in from an early stage, and because there were a lot of concerns from particularly stakeholders, like how we deal with some refugee claimants who can be in very vulnerable situations. For example, those who are living in shelters, or those who may only have a cell phone, where that's seen as not an ideal way to connect to these hearings. And but now that we have had these implemented for some time, we're looking at it and we look back on some of the processes of how people interacted with the system in the past. For example, we only have a certain number of offices in the country. And so there were claimants from places like Halifax on the Eastern Seaboard, where they would frequently have to travel hundreds of kilometers to Montreal to attend the hearing. And now there's a much greater ease with which they typically connect to a hearing using these virtual methods. And as the nature of our pandemic restrictions at our offices have changed, and we've opened up more opportunities for people to return in person, when we look at the decisions that are being made, we are not getting a lot of applications to go back to the way that things were before. And so we then look at all of this. We record videos of the hearings, hired law students to review those hearing videos as part of our quality measurement initiatives. And ultimately, one of the things that we couldn't have done all of this without was the support of that council community, where council did things in the midst of the pandemic, like rent extra office space, buy additional computers to have for their claimants in their offices, really take extra steps to help with this type of transition and understanding of technology by many of those who were connecting to the hearings. And so that was something where if we didn't have that type of relationship and support to keep the hearings going during that time, the project surely would have failed. And so those are some of the key aspects, and there were a number of others that we thought of, everything from doing training on assessing credibility in this virtual environment and how that may change, to other initiatives that looked more at how we measure quality. But I will now turn it over to to cyber justice and Nicolas for your part of the presentation.
Thank you, Joshua. As I'm just loading my presentation, I'll just take a few seconds to apologize to everybody. Unfortunately, I tested positive for COVID a few days ago, so I'm not at 100% as you may guess. And so apologies if my energy level isn't all that great, and for the fact that it's not just the lighting that makes me look so pale. I'm actually, unfortunately, a little bit under the weather, as you might guess. That being said, I truly wanted to be here, hence why I decided to fight COVID to be with you, simply because this was really a labor of love, this particular mandate that was given to me by the Immigration and Refugee Board of Canada. And the idea really was to say, okay, well, we are moving forward during the pandemic. We are using this technology. A choice was made, as Joshua explained, to use Teams. But there was a willingness to ensure that, well, this was the right decision, and to make sure that if there was a choice to keep on using video conferencing post-pandemic, well, to make sure that this was done respecting the rights of the different stakeholders and ensuring that access to justice was not negated by the platform. Of course, during the pandemic, there was no real choice, but after the pandemic, obviously, there could have been a decision made to go back to the previous way of doing things. And of course, we know all the anecdotal evidence of issues with video conferencing, couple of quotes that you've seen in the past couple of years in the media, the doctor who joined Zoom, who was testifying while he was operating on a patient and was asked to at least sew the patient up before he would actually answer questions by the judge, or the Brazilian judge who appeared shirtless on Zoom, or the now classic "I am not a cat" from the lawyer in Texas who had a cat filter on his face that he could not remove. Now, obviously, these are all funny anecdotal stories, but the real question was, well, is this something that we should worry about, or is the use of Teams to hold hearings online for the IRB, is that something that we should be concerned with? And so I was asked to basically conduct more or less an audit of the practices of the IRB, as Joshua explained, and to do so, the attack that we chose together with the IRB was not to evaluate if people were satisfied or dissatisfied with the technology, but rather if people felt that the technology granted them a sufficient level of access to justice. So if they felt that they had access to justice using Teams. And so I used the Access to Justice Index that was developed by my former colleague, then Professor Jean-François Roberge, who's now a judge here in Quebec. And the methodology that he developed basically was to establish the sense of access to justice when using an ODR platform. And so obviously the test was somewhat modified because this wasn't a ODR platform in the classic sense of the term that we in the ODR community think of. But this was still ODR in the sense that it is a dispute resolution conducted online. And so I modified the survey that Jean-François had drafted previously to evaluate the Parler platform that my team and I at the Cyber Justice Laboratory developed, Parler being our platform to aid in the resolution of litigation electronically. And I think I saw that my colleague Mark Linton is actually here today, and he will present Parler in a couple of days. And so if you're interested, you can log on for his presentation. But yeah, so we took took that survey and gave it basically as an exit survey to everybody who used the platform during that summer, so the summer of 2021. And of the, I don't know how many hundred people actually had hearings during that summer, 270 participants answered. Of those 270, as you can see on the screen right now, 42 were people who appeared before the IRB, so more often than not, refugee people who were requesting refugee status, or basically people who wanted to immigrate, possible immigrants, I'm sorry. And then you had some of the representatives, so representatives for the people who appeared before the IRB, and finally CBSA hearing officers. CBSA is the Canada Border Services Agency. So basically, they also have to give their thoughts during these hearings. On top of this survey, which is really what I'm going to concentrate on during my presentation, but obviously we completed that work with a series of questionnaires that were sent to IRBCC members, so members of the board, of the committee, the consultative committee, basically asking them how they appreciated the process. I attended a few hearings, and since hearings in front of the IRB are confidential, I had to get special security clearance. So obviously, I won't be able to discuss the content of these hearings, but there are a couple of elements that I can point out. And finally, reviewed some of the documentations as well as the virtual ready tour that Joshua related to, and obviously all of the pertinent literature out there. So what did that allow us to do? Well, it allowed us to come to to make a few findings, 9 in total. And those are really the crux of the study itself. And so basically for the remainder of my time, just very quickly going to go through these findings and just point out a few elements for each that I find particularly pertinent, specifically for the audience that I'm talking to right now, people who have an interest more broadly in ODR. And so the first one, and I think the most important one, obviously for the IRB, was to establish, well, is there a high level of stakeholder satisfaction? Do they believe that they've had sufficient access to justice? And as you can see, the general sense of access to justice of all participants across the board was 86%. Now, obviously, 86% might seem like an extremely high number. It needs to be taken with somewhat of a grain of salt. It is higher than similar surveys that were conducted in other situations. For example, in Quebec, the same survey was conducted for hearings, mediation sessions held by judges, and they got I believe, 83% success rate. So again, it is relatively high, but of course, as I mentioned, the test was modified somewhat, so it's not the exact same test. So we're not comparing apples to apples. And the other thing is we can't compare it yet to what happened prior to the use of technology. So clearly people seem to be sufficiently satisfied with the technology, but what we don't know is if their satisfaction level was higher or lower when they were actually attending in-person hearings, because we don't actually have any data on in-person hearings. But as you can see, and I'm obviously not going to read down the list, you can do so yourselves as I'm speaking, you can see that, again, the percentages are pretty high across the board. But what's fascinating, and that will lead me to the next element, is that very often I write lawyers, and I should probably have written representatives because they're not necessarily lawyers, but the representatives' assumptions did not always correlate with their clients' expectations. And what I mean by that is that very often when looking at the data and when looking at actual answers that people gave me, individuals had a higher level of satisfaction than their representatives thought they did. So people, for example, thought that, well, the platform made it a lot easier for them, and basically they felt more at ease, they were less stressed, they were less bothered by the whole process. which their lawyers or representatives, again, did not necessarily read the same way. And so that just goes to show something that we already knew in the ODR community, and that is that very often those of us within the legal profession will assume certain behaviors, will assume certain things on behalf of our clients that just don't pan out. And to make an interesting parallel, and this obviously has nothing to do with the IRB, but I think this is probably the best example of this that I've heard, and this is a judge in Quebec that for people who were basically registering their plea, and in Quebec, they have a choice to do so via video conferencing from where they are being detained, or they can ask to be in person in front of the court. And obviously, lawyers will find legal arguments to justify which is the best way to act. So obviously, you stay in court, you stay in your jail cell if you want to reduce costs or delays, but you go to the courthouse to register your plea because you feel your right to be present is important. But when the judge actually asked the detainees themselves, well, why did you choose to come to the courthouse, or why did you choose to stay in your jail cell and register your plea using video conferencing? Well, those that said, well, I wanted to stay in my jail cell to register my plea using video conferencing did so because they wanted to keep an eye on their property. They were basically afraid that that their cellmates or other people in the jail would steal their property. And those that actually wanted to come to the courthouse to register their plea did so because it was easier for their family to visit them at the courthouse than at the jail, because the courthouse is right in Old Montreal, so it's very easy to get to by subway. And also the food at the courthouse is much better than that at the jail. And so again, this has nothing to do with the IRB, but it goes to show that very often there's a discrepancy between how representatives and their clients will actually interpret a particular situation. And we also see that the clients are a lot more pragmatic, and their arguments are rarely legal. It's, I'm feeling more comfortable because I'm home, I'm in my own things, I have my close ones around me, and not well, if I were in the courtroom, I would have the better right to be, my right to be heard would be better served because we're all in the same premise physically. Third element I want to get to is, or the third finding was the lack of data. And I referred to that a few minutes ago. The lack of data regarding what happened prior to the pandemic, i.e., well, how were people satisfied or dissatisfied with what was going on with in-person hearings. And so we can't really compare. And obviously, the data that was obtained during the pandemic was relatively limited. Again, this was just during the summertime. So one of my recommendations, and Joshua just demonstrated that it was followed, was basically to keep on gathering such data so that they can update the study basically and correct things along the way. But more generally, we just have a lack of data regarding the use of technology in general. Now, obviously, many of the people that are here right now, myself included, have been studying these things for over 20 years now. I've been working on ODR since 2001, and I can see some names here in the participants that were already household names in the field when I started. So again, there are a lot of us that have been working on these issues for over 20, 30, even 40 years. But truth be told, that's nothing. This is a quote that I use in almost all of my presentations from Walter J. Ong in his famous book, Orality and Literacy, who basically explained that the only reason that we finally understand our relationship to paper is because we finally moved on to a different medium, and we're now using technology, well, computers. And so to think that we, after using this technology, these computers for about, what, 45 years now, and if you're talking about the internet for roughly 25, 30 years, Well, that's nothing when you consider again that we had been using paper for decades, for centuries even, and doing so without necessarily understanding exactly what was going on. And so we have to cut ourselves some slack, basically, and understand that we're not going to figure out tomorrow morning exactly what the impact of these technologies are. Fourth finding was something that, again, many of you in the community are very familiar with, and that was the loss of ritualization. One thing that struck me watching the hearings is how almost friendly they were. Very often it was difficult even to discern who was actually the member that was holding the hearing because of the way Teams works, that basically depending on when you log on and who speaks last, that person might be bigger on the screen, and unless you use the pin functions, people might shift around. And so in certain cases, because a translator was so important because that individual kept talking, well, they were the ones that were visible, and the deciding parties, the members, so basically the equivalent of the judge or arbitrator, that person was more removed, if you will. And also there was no structure as to backdrops, so it wasn't necessarily clear, again, that they represented the state. And so in my recommendations, these are certain things that, recommendations that I made, and one of them was as simple as adopting a general background, which seems to have been followed now. So yeah, regarding ritualization, again, just the idea, and this is a quote from my a book from my colleagues Karim Beniclef and Fabien Gélina back in 2005, where they basically explained that rituals in law are extremely important, and we need to understand them, we need to identify them, we need to figure out if these rituals are still pertinent. And if they aren't, then we can brush them aside. But if they're not, if they remain pertinent, then we need to find a way to adapt the rituals so that they still work in the online environment. And one of my recommendations was to do just that. And then you have a series of fears. And I should point out, these were fears that came from the literature review and sometimes by observers, but not necessarily by the respondents to the survey. The first one was fears regarding witness tampering, and you read a lot of that, and the media contains a lot of that. Of course, there was the Kaushal case here in Canada, where it was established that there was, in fact, somebody helping a witness. And the screenshot that you have on the left-hand side of the screen was this famous case in the US where the gentleman who was accused of spousal abuse was actually in the same apartment as his victim when he was testifying, and the lady that you see, Deborah Davis, was the prosecutor, and she is the one who put two and two together and asked the judge to intervene. And the judge was very smart. He asked the gentleman to go outside and with his phone to show what the address was that he was at, to demonstrate that he wasn't in the same room as his presumed victim. And as you can see in the bottom right corner of that screen, the police officers came in and arrested him during the trial because he was there in the same room. Now, these fears, although, again, there are these cases and there are others, were not really considered as problematic by most respondents to the survey and by most participants. And in fact, there are relatively simple ways, and this particular case demonstrated that, of settling whether or not there's somebody else in the room. As I said in my recommendations, you can simply just ensure that the person has their back to the only door in the room, and to basically sweep the room with the camera before they start to ensure that there's nobody else in the room. Now, is there still a possibility of having somebody help the witness? Of course, but it's not like witness tampering was never an issue also prior to that. Sixth finding, fears regarding the loss of nonverbal cues. And this is a recurring one, right? And everybody in the ODR community has heard this one a million times. Every time we present a new ODR platform that is based on text exchanges or written documents, there's always the, yes, but if I don't see the other party, how do I know if they're telling the truth? And I quote this paper by Susan Bandis and Neil Fagerson, where they explain, and they're quoting Justice Easterbrook, of course, of the famed, who is famous for the law of the horse debate, who basically said that, well, as you can see, it's dubious folk knowledge that we are good at reading nonverbal behavior. And in fact, study after study, at least all the studies that I was able to find, basically say that we're barely better than flipping a coin at reading nonverbal behavior. And so it's probably a good thing that we have less access to nonverbal cues, because that way we're not going to be thinking that we can identify something that we just cannot. Fears regarding the dehumanization of the process. That again is something that I saw a lot in my literature review, something that I personally observed during the hearings. And it's basically the fact that obviously if we're all behind the screen, we're not really communicating fully. And in most cases, that's perfectly fine. There was this one case, however, which was heartbreaking, where the person who was asking to come to be let into Canada, basically during a break, forgot to turn off their camera. And so that individual and myself were the only ones that were in the hearing room. And I say I was in the hearing room, I was watching a recording, so he didn't know I was there. So he was basically alone in the quote unquote hearing room, so alone on Zoom, or on Team rather. And he just started sobbing because he knew the case wasn't going his way. And obviously, all I wanted to do was go through the screen and try to basically tap him on the back and say, don't worry, it'll all work out. And in fact, at the end of the hearing, while things didn't necessarily go the way he wanted, he was given other options and was given hope. But the idea that obviously he was alone in his apartment, had no one around him, that pulls at your heartstrings. The fears regarding technical issues, obviously, I can go through these for hours, but it's something that you're all familiar with, and something that Joshua mentioned as well, and something that really was worked on quite a lot by the IRB, anything they could do on their end. But of course, the problem is, as you know, there are going to be issues on the end of every individual that is logging onto the team platform. So who knows where the issue comes from. And finally, fears relating to security. And again, Joshua mentioned a lot of these. So obviously, there are the fears regarding trolls or third parties, and knock on wood, it hasn't happened during this presentation, but obviously people that try to disrupt using what is referred to as Zoom bombing. Again, a possibility, but something that can very easily be corrected. Then there are all the questions regarding obviously where the data is being housed and where the data is circulating. And that was a big preoccupation for many of the people who answered the survey, simply because obviously if you're requesting refugee status into Canada, the last thing you want is for the country that you are coming from to have access to that information. And so, as you heard Joshua explained, the workaround for that was to ensure that the data was housed here in Canada. Now, obviously, that doesn't change the fact that information could still circulate outside of Canada and therefore be intercepted. But then the risks are not as high. And so that was an overall what general findings were, and that led to a series of recommendations that you can see on the screen. Obviously, very small, but I'll give you the link in a few seconds to the actual survey. And I also, in the study, talked about a few of the best practices, and I want to draw your attention to two of them. The first one is the need to adapt the process. Obviously, and this is something that we're all familiar with, again, the idea that technology is not neutral, and therefore you want to make sure that the technology is going to help the process and not hinder it. And so certain adaptations were deemed necessary. And one of those adaptations is to properly configure the platform, in this case Teams, but other tribunals are using, or courts or tribunals are using Zoom, in order to ensure its best use. And I was actually a few weeks ago at a conference where I was seated at the table with a representative from Microsoft, who actually showed me screenshots of what is believed to be the next iteration of the Teams platform, or a package that would be available for Teams for the courts. And so where it is a little more adapted, a little better configured to the needs of courts or tribunals like the IRB. I don't know. Again, this is a beta version that I was shown. I don't know when that will be made available, or even if that will someday be made available, but it's at least good to know that Microsoft is working on adapting these tools that, let's face it, were not created for the courts, but adapting them so that they serve the courts a lot better. And so on that note, I will simply thank you for your attention. This is the link to the full report that is available online on the IRB website. And I believe now is a time for questions. Thank you.
Thanks very much, Nicolas. That was an excellent presentation. And as someone who did their doctoral research on a dispute resolution evaluation, I want to compliment you. The report that you did was very, very good, very readable, and very well done. Negar Azmudeh is with us as well. She is the director of the quality branch for the Immigration and Refugee Board. Did you have anything you wanted to say before we headed off into questions, Negar?
No, I just thank you very much for inviting me. I just wanted to reiterate that the security issue that both Nicolas and Joshua mentioned had initially posed quite a bit of challenge, because all of our processes are private hearings. So some of the models that other courts or tribunals that dealt with public cases had adopted did not really apply to us, and we had to really customize our processes in answer to that challenge. And I don't know whether you have more questions or not on that, but that created some extra challenges going forward.
And I think one of the things that has sort of briefly been mentioned, but I think it's worthwhile putting out, is that especially for our American and overseas colleagues, Canada is a bilingual country, and this is a federal tribunal. So the tribunal operates in both official languages and has interpretation services to bring refugee claimants from basically every language group across the world into the courtroom, where there's spontaneous interpretation that goes on between the official language and the language of the claimant. So the claimants aren't forced to conduct the work in English or French, but their own choice. Obviously, the paperwork remains in either of the official languages, but that may be just a point of interest for folks not from Canada. And with that, I'll open, as it were, the floor or the chat. If you have a question, please just put up your hand and ask. You have experts please take the opportunity to speak with them. Well, I'm going to ask John, in the lack of other questions, because there's obviously, I mean, I've never known Daniel Rainey to be shy. So I'll ask a question on his behalf. Josh, you mentioned that so far you think about 100,000 hearings have taken place using this pivot to teams from bricks and mortar. How unusual is it to have the persons involved in disparate places? So you may have a member in Vancouver, you may have an interpreter from Calgary, you may have a lawyer in Montreal and a claimant in Northern Ontario. Is that an unusual scenario, or do you find that people are usually localized, or is there any kind of data on that sort of thing?
Sure. In the survey that we sent out, one of the questions that we've asked everybody in the survey is, where did you do the hearing from? Like, did you do it from council's office? Did you do it from the IRB's office? Did you do it from your home? And what we've seen there is that overwhelmingly, the applicant has wanted to be physically co-located with their council. So a significant majority of the time, that has been the case. And then there's been a smaller number where council are in different cities or different provinces from the decision maker, the interpreter, and the claimant. But that really becomes a choice for the individuals involved about what best works for them. Negar, is there anything you'd add to that?
I would just wanted to add that that's correct. However, it has offered a lot of flexibility for the board to manage its inventory nationally, because it doesn't matter as much where the member is located, and depending on the member availability, or sometimes, for example, in the context of a specialized team that is called gender-related task force, there were regions that had more members trained in trauma-informed adjudicative practices, and some of those cases could have been transferred over administratively and without much of a burden. So it also is allowing the board to think of managing its inventory nationally more broadly going forward, because traditionally we've been operating out of regional offices that are tied to where the person made the refugee claim upon arriving in Canada.
So there's two questions. There's two questions in the chat, and I have an additional one. And this can be for any of the three of you. Do you know if virtual hearings were or could be grounds for a reconsideration application, or in IRB language, an appeal?
Procedural fairness issues were issues that were raised ahead of time as we were discussing the possibilities of virtual hearings with the stakeholders, and we tried to build in natural justice elements that would deal with it. So in and of itself, because a hearing was taken place virtually, I think it's very difficult to make an argument that it's therefore unfair. But specific events may happen that raise procedural fairness issues. Like, for example, one of the extra challenges that we never had to worry about in the non-virtual world was when the member is delivering the decision, the final reasons orally. And the question of, in the past, the member would ask the interpreter to sit next to the claimant, and as the member was reading the decision on the record, the interpreter could provide simultaneous interpretation. In the virtual hearing world, there are ways to do it without raising procedural fairness issues, but they're more challenging unless the member wants to go consecutive interpretation, which takes a lot longer. So the little things like that, which whether or not they amount to a challenge, it's really a case-to-case basis. But it's a question of, for example, if there is a disconnection, and during the disconnection, something turns on the credibility of the evidence, it's a natural justice issue that could be a legal challenge and the decision may be overturned, but not because of anything in principle challenging the virtual hearing work.
Thanks, Negar. The next question I'm going to ask Josh and Nicolas to answer. What advice would you give to other countries, or in brackets yourselves 2 years ago, in undertaking this pivot?
Josh, would you like to go first?
Sure. So when we were rolling this out, one of the things that we did was liaise closely with other countries' systems that were at the time expanding the use of virtual hearings. And so we had a lot of meetings. There's a lot of coordination and cooperation in the refugee and asylum space between different countries. And so there was a lot of sharing of best practices through that. And that sort of active engagement as these processes are going along allows for more resilient and faster responses to new issues that arise. And I think that for us, one of the things that we did was just to try and go back to the basic principles. And I think you saw, like Nicolas, for instance, referring to some of the fundamentals about credibility determinations, whether that happens in a virtual space or whether that happens in person, the rules about things like demeanor evidence. It's long been the case in refugee and asylum proceedings that demeanor evidence is not looked upon as a reliable source of information for all sorts of cross-cultural reasons. And so the fact that it can have effects on how it might be taken in this virtual context should have less concern potentially. And so what we did all along was we brought in people that tried to go back to the foundational principles of how we should do this type of work, of stakeholder relations, of having a user-centric system, of trying to be empirical and measure how we are doing in order to be able to respond quickly. And I think those were some of the ways that we tried to implement this, and to the extent that we've had some successes with it, I think those were some keys.
Regarding ourselves in 2020, I would say it would be very unfair to try to criticize what was done in 2020 simply because we had, I say we, like I was part of it, but the IRB had basically days to adapt to the pandemic and to make sure that they wouldn't have a backlog of hundreds and thousands of cases after the end. So it would actually be going back to 2015 or 2010 even, and saying, well, maybe this whole technological shift should have occurred beforehand. And that's a general critique that we can make to all courts and tribunals almost around the world. The fact that it took the pandemic for most people in the justice departments everywhere to adapt to technology. As for what other countries, or what advice I would have for other countries, I would jokingly answer, read my study. The whole point of the study was just that, to point out all the good and the bad that was done. And I have to say it was mostly good in this case, but all of the decisions that were made, and to see how exactly that impacted the final result. And so, yeah, everything that I would have to say is in that document. And of course, if people have questions about it, they can obviously get in touch with me.
Erica, you have your hand up, and I'm going to just get you in about 10 seconds, but I just want to acknowledge that Ethan Cash has joined us. Ethan has been a couple of times called the father of ODR. He's definitely the founder of the National Center of Technology and Dispute Resolution, was its first director. So, hello, Ethan, thank you very much for dropping in. And Erica, I'm just going to introduce her by saying she's probably one of the best students I ever taught.
Yeah, thank you, Frank. I appreciate that. Anyways, hi everybody, and Nicolas, thank you for that study. I think it's fascinating, and I know I will want to read that in much more detail and pass it on as well. So I'm actually speaking here as a member of what's called the Impact and Values Committee of the North American what do we call, community mediation organization. It's actually, what do we call, North American Association for Community, NAFCA. Anyways, what I was wondering is when you were talking about helping people to become, familiar and comfortable when you do the ready tours, and I think it was Joshua that was talking about that part, about the ready tours on how to prepare participants to actually be, fully comfortable with the online system. Have you ever considered as your partners or stakeholders that community mediations across North America would be probably great partners? And the reason I'm thinking that is because as a former coordinator of the City of Calgary Community Mediation Program, where I got 3,000 calls a year, and most of them were culturally very diverse calls, that it would be a great introduction for newcomers, immigrants, people living in a city, in a community, to actually become familiar with community mediation and use their facilities to learn how to use online. And perhaps it was just a thought when this came up, because they are very culturally astute, they're great, they have translators. It's a great connection. So it's just an idea that I thought I would like to speak to in my next meeting with my Impact and Values Committee.
Thank you for that. I would say that one of the real opportunities that we've had based on moving to these more virtual processes, as Negar alluded to, is the ability to really engage with people regardless of where they're geographically located here in Canada. We've started, for instance, hiring decision makers, members in cities where we don't have any offices. And to that end, I would always also encourage people who are in Canada who think that they might be interested in this area or this line of work to check out our website, where we do have various job opportunities, including for this member decision-making role that we always encourage applications for.
Thanks, Sarah.
Yeah, they're usually volunteers too, like the members of the community mediations, and they really are spread out in all the small communities as well. So I thought they'd be a great connection. Anyways, thank you.
I have a question, and then I see Ethan's come on camera. So I'll after I've asked my question, if Ethan wants to say hello, I'll give him that opportunity. We are just a minute or two over time, so I'll keep it fairly quick. Josh, Negar, how many members are there in the Refugee Protection Division across Canada?
Around a little bit over 300.
300.
Yes.
And do you have any sense of how many of them want to return to the bricks and mortars environment, or versus how many of them want to stay in the online environment for their hearings?
Questionnaires have gone out and they've been compiled with that very question. And basically the board is preparing itself for its ability to conduct both online as well as remote hearings. So far, there are members who would like to come back, but the majority on occasions or some form of a hybrid return, I think very few would like to come back on a full-time basis.
Very good.
And if I may, that actually corresponds to everybody that was surveyed as well. That's the general feeling is in-person hearings should remain an option. You shouldn't have to be online, but online should remain a possibility and should be the de facto in most cases.
Very good. Thank you for that. And before we close, Ethan, would you like to say a hello? You'd have to come off mute if you're going to do that, though. There you go.
I think Zoom is designed very well, except for the mute, which everybody forgets about. Anyway, very quickly, thank you, Frank, for helping to organize or to organizing this. Frankly, there's no more important session during the week than this one. And I'm sorry I couldn't see the whole thing, but I'll definitely watch it, watch the video. Thank you for participating. And those of you who are in the audience, so to speak, thank you for being here. I've known Nicolas for 20 years, probably. I actually, among my first contacts in law and technology was with Nicolas and the group at Kareem and the group at the University of Montreal. So I have fond memories of many trips to work with them in Montreal. And I'll look forward to learning more about what you're doing, because what you're doing is so far ahead of what we in the States are doing, unfortunately. Thank you. Anyway, Frank, thanks. There was no need for this introduction.
Oh, well. That's okay. It's nice to have you. It's nice to have you there. If there's nothing else, if there is something else, please raise your hand. Otherwise, I'm going to say thank you very much to the colleagues from IRB. You did a great job in a short time of explaining a very important pivot. And thank you, Nicolas, for sharing your experience in evaluating the pivot and for providing very independent advice and recommendations. You acknowledge the good and you help to provide solutions and ideas around things that needed an improvement. And that's the hallmark of a good evaluation. So thank you very much for that. Ladies and gentlemen, if you can still hear me, I look frozen on my screen, but I trust you hear me.
Yes, we can still hear you, Frank.
Okay, very good. With that, I want to wish you, wherever you are located across the world, many thanks for joining us today. Thank you, Erica. Always lovely to see you and colleagues. We have met, and enjoy the rest of your day. And Nicolas, Josh, and Negar, if you want to stay for a minute and debrief, we can do that.